Welcome and thank you so much for joining us today for Gault at 50, examining a youth's right to counsel in Nebraska. My name is Juliet Summers. I am the policy coordinator with Voices for Children in Nebraska.
And my name is Christine Henningsen. I'm an attorney at Juvenile Center on Children, Families, and the Law, and I direct a project there called Nebraska Youth Advocates.
So just so you know, before we get started, there is a way to type questions into the GoToMeeting browser. So as we go, if you have questions, please feel free to type them in. If they're quick and related to something right there on the card, we may answer right away. Otherwise, we'll let them queue up and save some minutes at the end to answer any questions that you may have.
There's also two other resources or handouts that should be available to you on the GoToMeeting as well. Kind of a cheat sheet of LD 894.
And then the Voices for Children data snapshot on the data on access to counsel in the juvenile court across Nebraska that I'll be going through some of those numbers with you today. So with that, trying to turn the page, and it's not letting me. Seem to be on. Sorry guys, technical difficulty. We may need some technical assistance in here. Give us 1 second. Okay. Great, thanks. Just when you think you have it all covered. Okay. So really fast, I'm with Voices for Children in Nebraska. You may be familiar with Voices, but if not, we are a statewide, independent, nonprofit, nonpartisan child advocacy organization. As the policy coordinator, I do a little bit of research and writing. So the data snapshot that you have in front of you is one that I collaborated on, and do a little bit of public education, a little bit of committee work at the statewide level, in the areas of juvenile justice and child welfare in particular, and a little bit of lobbying with the legislature. Our mission and values are that with kids at the center of our work, informed research drives our direction. When a policy is good, we support it. When it's harmful, we fight it. When it's missing, we can work to create it. And community engagement is how we promote systems change.
And like I said, I direct a new project at UNL Center on Children, Families, and Law called Nebraska Youth Advocates. Our hope is to serve as a resource center for juvenile defense attorneys in Nebraska. Striving to do this by doing some hands-on training, resource development, and technical assistance for defense counsel in Nebraska. Also working on policy advocacy, promoting best practices in juvenile court practice. Some people who are on the webinar today recently were certified in our trainer certification course in July, and we're really excited to make an impact and provide support to juvenile defense attorneys across Nebraska. So what we're going to do today is kind of take a look at the Supreme Court's ruling in the case of In re Gault on May 15th of 2017. It'll be the 50th anniversary of that ruling, and then we're going to be looking at kind of what the access to counsel looks like here in Nebraska for children who are involved in delinquency or status cases, and also talk a little bit about what are some next steps that we can do, where do we go from here. So In re Gault, one of the most memorable quotes from that comes from Justice Abe Fortas saying, "Under our Constitution, the condition of being a boy does not justify a kangaroo court." So even with the rehabilitative purpose of juvenile courts, too often youth were being faced to be in court without the protections that are afforded to us through the Constitution. So a little bit about the background of the story. Jerry Gault, he was a 15-year-old boy who was sentenced to serve nearly 6 years in a state industrial school for allegedly making a prank phone call. After the phone call, he was taken into police custody without his parents being notified, and he reportedly confessed to the crime without a lawyer or his parents present. He was never advised of his right to an attorney, and he went all the way to the Supreme Court through the appeal. In Arizona, at the lower appellate levels, his disposition to the state industrial school was upheld, and it wasn't until he made it all the way to the Supreme Court that it was reversed. And what did the Supreme say? They determined that that trial or lack of trial violated his constitutional right to due process. And it was the first time where they said the Constitution applies to every citizen, every child is guaranteed those rights. So even in the specialized juvenile courts, children must be afforded their essential rights. These rights, especially the right to an attorney, the cornerstones, of our justice system. And they also went to talk about why it was so important that they have assistance of counsel, recognizing that kids are not necessarily skilled in on the intricacies of law to know whether or not the elements of the crime could be met by the prosecution, to insist on regularity of proceedings, and also to appreciate the consequences of the adjudication. So the essential rights that In re Gault guaranteed, obviously the right to counsel, the right to have notice of charges against them, the right to remain silent, and the right to cross-examine witnesses. So here we are, nearly 50 years later, and it's time to take a step back and see if we are fulfilling those promises of Gault. Across the nation, there's still lack of access to counsel for youth, inadequate juvenile defense delivery systems, and practices that are inconsistent with adolescent development. Lots of times juvenile court is still looked at on as kiddie court or a training ground for young attorneys, and really it's a specialized practice where attorneys need to have specialized knowledge about adolescent development, while also having the knowledge of complex motion practice, and also navigation of the various systems which our families come involved with. Also, the early appointment of counsel is necessary. Too many times counsel is afforded to a child too late into the proceedings, post adjudication, when it's hard for the attorney to make a real impact on the case itself. Inadequate juvenile defense delivery systems. I think we saw that recently with a report from the Department of Justice from St. Louis County. In there was one public defender that was assigned all 394 juvenile cases that were opened in the year 2014. Also, there still are practices inconsistent with adolescent development. We are continually learning more about how a youth develops, their capacity for understanding effective communication skills with them. In 2011, the Supreme Court recognized in JDB versus North Carolina concerning waiver of Miranda rights that juveniles are more likely to feel pressure to waive Miranda rights, and they have to take juveniles' age suggestibility into account when assessing validity of waivers, and that is also true in waivers of counsel. Special care needs to be taken to ensure that the youth understands what right to counsel is and what it means to waive that right. And just, I think everyone on the webinar recognizes, but every youth, whether they're in juvenile court on a misdemeanor or a felony, is facing potential out-of-home placement, detention or staff secure detention, court-ordered treatment in months or even years on probation. I put this quote here from Powell v. Alabama. That's in the adult criminal context, saying that even the intelligent, educated layman has small and sometimes no skill in the science of law, requires a guiding hand of counsel at every step in the proceedings against him. This is even more true when we're dealing with youth who are involved in the court system. Youth are our most valuable assets and also our most vulnerable defendants. So we wanted to take a look a little bit too about where we're at in Nebraska case law. There's two main cases that discussed the waiver of counsel. Case of first impression was the in re interest of Dalton in 2007, and then in re interest of Justice V in 2011. Now, in that case, they did say at the time of the waiver, the burden is on the state to show the waiver was knowingly, intelligently, and voluntarily made. However, at the time, if a youth is asking to withdraw that waiver, at the time of that motion, the burden is actually on the youth to show by clear and convincing evidence that it was an involuntary waiver. The state Supreme Court decided to use the same standard as in adult cases involving waiver of counsel. And even though the Supreme Court did say that courts must take special care in scrutinizing a purported waiver of rights of counsel and take special, extra time to conduct a sufficient inquiry into the juvenile's understanding of the right to counsel and waiver, the case of In re Dalton involved a 9-year-old who was mildly mentally retarded and whose mother told him to waive counsel. So even though the court said that the lower courts needed to take special care in scrutinizing a purported waiver, they found in those facts that it was not sufficient to withdraw the plea. They found it was not an abuse of discretion to withdraw the 9-year-old's admission. They said to look at the totality of the circumstances. So it's kind of a balancing test, and those were age, intelligence, education, juvenile's background and experience in general and within the court system, the presence of the juvenile's parents, the language used by the court in describing the juvenile's rights, the juvenile's conduct, the juvenile's emotional stability and intricacy of the offense. So even though we have this case law, there is still kind of a disconnect between this and ensuring that youth make a knowing, intelligent, and voluntary waiver of that counsel. Now, this case law all predates the changes in LB 894 that Juliet is going over, but I just wanted to point out that even though a youth can waive the right to counsel, to ask to withdraw that waiver of counsel is not an easy task. Also nationally, the Department of Justice in 2015 filed a statement of interest in a case in Georgia where Attorney General Eric Holder stated that for too long the Supreme Court's promise of fairness for young people accused of delinquency has gone unfulfilled, also urging the right to a competent attorney at the earliest point in the petition, and for that representation to continue at least through the disposition process. Went on further to say that should a court determine that children are regularly waiving counsel without first consulting with an attorney, the court can and should find that resulting waivers amount to a system-wide denial of the right to counsel. In other years, the Department of Justice has issued findings about inadequacies of juvenile courts in Memphis, in Shelby County, Tennessee, and St. Louis, Missouri. So it's something that's on the radar of the Department of Justice, and something that we need to look at as a state. So part of the Gault at 50 celebration to the National Juvenile Defender Center has come up with this statement of principles kind of which they are striving for, these steps that would help us fulfill the promises given to us under Gault. So you can read those, and there's a whole website that you can go on there too. We'll talk about how you can sign on to these statement of principles, but these are kind of what the National Juvenile Defender Center has come out with, so people take time to refocus on what was said in Gault and examine where we're at presently.
Thanks, Christine. So this is Juliet again. I'm going to take over and kind of go through a state of the state based on the data with you right now, and then talk about some legislation that passed this year that sort of sought to move the needle a little bit on these numbers that I'm going to go through with you. So all of the data we're going to talk about today comes directly from the Administrative Office of the Courts through the justice system. So when a case is entered into justice, there's the clerk who's entering it in the given county office, and then those numbers are that raw information is filtered through the Administrative Office of the Courts, and they published this data report, the Nebraska Juvenile Justice System Statistical Annual Report for 2015, which was required by statute. Nebraska by statute 24/1007 required this report. So what Voices for Children did is we took a look at this report, and I highly recommend you go to the Supreme Court webpage and go to the Administrative Office of the Courts, look up reports, and go through this report yourself, because there is a lot of county-specific information in it, which is really good information to have, not just about access to counsel, but about placements on probation and outcomes on probation, out-of-home placements, etc. It's a really good amount of information in there. So what we did was, specific to the issue of access to counsel, we took the numbers that the AOC was publishing, and we sort of sliced and diced them and made them, packaged them in ways that might be a little bit more readable, and also, did a specific focus on access to counsel, since the Statistical Annual Report covers a lot of information. And so that is the data report that you should have access to through this webinar, Juvenile and Justice Access to Counsel Across Nebraska. And that is what I'm going to go through with you right now. So the first data slide I'd like to share with you is, this is statewide, divided into judicial districts, the percent of kids with counsel by judicial district. So we know that overall, our state rate of juvenile access to counsel, this is specifically in juvenile court proceedings, either separate juvenile court or a county court acting as a juvenile court. This is what the rate of counsel looks like by district, and statewide it is 62%. So despite Gault and despite the status in Nebraska where any kind of charge you have in juvenile court could expose you to out-of-home placement, only just over 6 out of 10 kids are getting a lawyer. And as you can see, that number is really being pulled higher by our separate juvenile courts. So specifically, Douglas County has a 94% rate. Lancaster County, which is District 3, has a 63% rate, and then Sarpy is in District 2, and there's an 88% rate there. And sort of the rest of the state varies a little bit, but it's pretty much in the 35% to 45% range throughout the rest of the state. So I went through this a little bit, but county with the highest rate is also our county that has the highest total numbers. So in Douglas County in 2015, there were a little over 1,600 cases filed, and of those, a little over 1,500 kids had access to a lawyer. And the number of counties with the lowest rate of counsel all had 0%. Now, it should be noted that the largest total number of kids was Polk County, which had 7 cases, of which 0 kids had counsel. The others were like 1 to 2 cases in the whole year. And so, when we think about possible factors that are contributing to the low rates of access to counsel, low case numbers is one of them. If you have very, very, very few kids coming through, you may not have, jurisdictional mechanisms set up, or potentially a practicing juvenile court defense attorney in your area. Obviously, the separate juvenile courts, they see so many numbers of kids, much higher numbers, that they have designated public defender offices there to represent. They have their own structures and systems, and they also, being separate juvenile courts, this is all they do day in, day out. They don't have, as a county court does, they don't have to switch hats midway through the day. Another possible contributing factor is the way diversion might be structured in different counties. So when we think and talk about diversion in the child advocacy world, it's to divert from court. So we think of diversion as being entirely a pre-court process. And something we learned this year, as LB 894 was making its way through the legislature, was that there are jurisdictions in Nebraska that have structured their diversion system to actually be post-filing. So a county attorney might file a case in the juvenile court, but then refer it to diversion. And so in those cases, even though the child comes to court for that filing, they may not be getting assigned an attorney, because when they show up for that first appearance, the court and the county attorney are saying, we'll send you to diversion instead. What's not totally clear in those structures is how the case then pans out. If the child fails at that diversion program and they come back to court, the county attorney brings the petition back, are they getting counsel at that point? It's not clear. And then the final speculation about possibly why that we have a low rate of actual appointment of counsel is the way counties might look at juvenile proceedings. So if say a county court judge who is mostly dealing with adult cases gets a juvenile case and say it appears to be a pretty minor charge, there might be a perception that this isn't as serious, this isn't, the gravity of the charge is not a big deal, so we'll sort of just take care of this pretty easily and quickly. The kid doesn't need a lawyer for that. And we did hear some of that again in, as the legislature was considering LB 894, there was some testimony and some emails coming in saying, we deal with really our minor cases in the juvenile court, and so those cases don't warrant lawyers. Of course, as we saw, for instance in Dalton, it can come into the court seeming like a pretty minor case, even say a status offense case, but can result in really significant consequences for the child. So the next data point I'm going to walk you through pretty quickly is access to counsel by gender. I'm highlighting this one because I think it's really striking when you look across the state. In every single judicial district, girls are getting appointed lawyers or retaining lawyers at a lower rate than boys. So the statewide number, the statewide rate is 64% of boys had access to counsel in the juvenile court in 2015, only 57% of girls. Pulling those numbers out a little bit, our greatest male to female gender disparity was in Nuckolls County, so 5 girls, 0 had counsel, 5 boys, 3 had counsel. Again, really low numbers, but you can see that disparity there. And interestingly, the disparity exists even in Douglas County, where appointment since 2011 has been automatic in all cases, which it leads to the very high rate of access to counsel overall. So in 2015, there were 513 girls who had new charges brought, and of them, 474 had counsel, 92%, whereas we had 1,100 boys, so significantly more boys involved in the juvenile court. And of those, 1,042 had counsel, and that was 95%. So when we saw these numbers at Voices for Children, we were really curious, like, what is going on with this? A bunch of national partners to see if anyone else across the country had done any research into this or had information about why this might be. it sort of came up empty. It didn't seem like anyone had access to the data the way we do in Nebraska through the justice data set. So no one else had seen numbers like this, but they did have some suggestions about possibly why. So one potential answer is the type of charge. Again, if a court or say a family is coming into court and thinking this charge isn't a very big deal, shouldn't be too onerous of a process, I'm not expecting any serious consequences from juvenile court, we don't need a lawyer. Girls tend to be charged with lower level crimes than boys. That's a broad generalization, but it is there. So that's one possibility, that maybe the girls are coming in broadly, generally on lower level charges, and so there's a sense either from the courts or from the families themselves that that it's okay to go forward without asking for a lawyer or without offering a lawyer. Another possibility, again, is referral to diversion. So if you are coming in on a low charge and you're in a county where diversion is offered post-filing, maybe girls are having greater access to diversion programs than boys. And then a final suggestion that was made by some of our national partners was there is some evidence of ongoing gendered protectionism in juvenile courts where possibly courts are taking a more protective approach of girls, and if you are combining that with a sense of you only need a lawyer if it's a serious case, potentially there is greater pressure on girls to waive their right to counsel because we're going to take care of our own here. But that is pure speculation. I have no data or evidence to back up any of those suggestions, just some thoughts from experts on why that could be. So the final data slide I'm going to share with you is one that actually didn't make it into our data report. So you are the first people seeing this publicly. And I'll sort of explain why in a minute. But what we did is we charted counties by access to counsel. So the rate of counsel being involved in a case, going from lowest to highest, that's that thicker blue line. And then admissions, so if the child in a juvenile proceeding admitted to a charge. And what you need to know on these data points is that the AOC, Administrative Office of the Courts, what they did was they tracked admission to the highest charge on a petition. So a petition with a felony and a misdemeanor, say, if the child pled to the felony, that would only show up once on here as a data point as a felony admit. There wouldn't be any information about the misdemeanor being dismissed. Versus if this child on that same petition pled to a misdemeanor, it would show up once as a misdemeanor admit. So, so what can we say about this chart? Some important things to consider. First is actual numbers versus percent. So I'll jump kind of back and forth. The highest admission rate was 92% to status offenses in District 8. That's that tall orange point kind of in the middle. But you need to know that was only 12 cases. So 11 out of 12 kids charged in north central Nebraska in 2015 with a status offense, so maybe truancy or maybe minor possession, 11 out of 12 admitted to that status offense. Whereas the lowest admission rate was also to status offense charges, and that was in District 3 in 2015 in Lancaster County. That was 239 cases total, and only 108 of those admitted to that charge. So that's the low orange point down here, District 3. So things you have to keep in mind, and ultimately why we decided not to put this chart in the data report, was there's just a lot going on in why these numbers might or might not be correlated with one another. One question could be the timing of the appointment. So it's not totally clear from the AOC's data report when the lawyer comes on board. So they are tracking any cases that had a lawyer, and I think it's at any point. So in this chart that we have, some of these admissions could be happening and then a lawyer is appointed later in the game. We just don't know. Another thing, of course, you're probably as lawyers thinking of the role of plea bargaining. So if the chart is only charting admission to the highest charge, there are going to be many, many cases, especially over in Douglas County, say, where there's a lot of cases coming in, where the child is admitting to the highest charge and getting others dismissed, or making a plea deal to plead to a lower charge and getting higher charges dismissed. And then, so the other thing to consider is this only tells us how many admissions there were to charges in the juvenile court. It doesn't say anything about whether the child went to trial and the case was dismissed, or if it went to trial and the charges were found to be true. So it's only looking at admits. So what can we say? The reason I wanted to share it with you on this webinar today is that at the very least we can say that rates of admission to charges don't bear out the claim that lawyers are going to stop up the works by litigating everything. If you look, there appears to be some correlation over by D6 and D3, whereas the rate starts to go up of appointment of counsel, the rate of admit goes down in Lancaster County, but then it sort of evens out in Sarpy and Douglas. So if you are in a jurisdiction that is considering increasing access to counsel, but maybe decision makers are concerned that lawyers are going to completely stop things up and they're going to try everything and it's going to be super costly and really inefficient, this chart might be helpful for you to say, hey, look, it hasn't played out that way in jurisdictions that have high rates of access to counsel. Kids are still making plea deals. They're still admitting when there's evidence there. So we can at least say that with these numbers. Oh, yeah, Christine.
One other point to make, too, was pointed out in the Inspector General of Nebraska's report in 2015. There was a problem with, youth were unrepresented in court, and they highlighted one case that they had found where a youth had been involved in the juvenile court system for over 6 years, had been in and out of the YRTC several times, that entire time without access to counsel too. So, obviously there are those cases out there when the youth is not represented, lead to longer terms of probation, more resources spent, when, an attorney could have helped counsel the youth to get to the right services so that they weren't lingering within the court system without any advocacy.
So that kind of leads us to, that was where the numbers were in 2015, and the legislature did kind of look at these numbers, and in 2016, this year, a bill was passed, LB 894, that you're probably at least a little bit familiar with. I'm going to go, it had a lot of other stuff in it too. I'm just going to talk to you today about the access to counsel pieces that changed in this legislation and that went into effect in July. So this is status quo where we stand statutorily in Nebraska. So the first thing is access to counsel while in custody. Previously our statute just said children in custody shall be permitted to contact a lawyer. It didn't say anything about whether they police or government officials should inform them of their right or inform them of their right to have counsel appointed. Obviously we have a Miranda protection there too, but the statute changed so that going forward, if a child is in custody of law enforcement or other government officials, which from my perspective would include school officials, if they're in a public school system, they must be informed of their right to counsel in developmentally appropriate language and informed of their right to have counsel appointed. The next piece that changed was in counties with over 150,000 inhabitants, or 150,000 or more, so that is Lancaster, Sarpy, and Douglas only, counsel shall be appointed at the time of petition filing on delinquency and status charges in the juvenile court. And counties of fewer than 150,000 inhabitants proceed as before. This the bill was not initially drafted this way. Initially, it was drafted to have counsel appointed at the time of petition filing across the state, because as we saw in our the map earlier, actually the highest rates of counsel appointment are already in those largest counties, and it was really outstate Nebraska or western Nebraska where the kids coming through juvenile court have a pretty low rate of access to counsel. However, there was a fight on the legislative floor over this provision, and this was the compromise amendment that ended up being crafted. So in those counties with 150,000 or more inhabitants, Douglas County was already doing this. So if you are a practitioner in Douglas County, your life shouldn't really change much at all, because counsel was already being appointed at the time of petition filing just by local court practice. But in Sarpy and Lancaster, if you are representing kids, if you're on the appointment wheel or if you're part of legal aid, probably your case numbers are going to go up a little bit, especially in Lancaster County. And the third thing that LB 894 did in regards to access to counsel, and this provision applies statewide, it set some pretty strong requirements about waiver of counsel, so trying to address some of maybe the flaws of Dalton. So first thing, there has to be a procedural process around waiver in court. It has to be made in court, it has to be on the record somehow, some kind of recording, and it has to be confirmed in a signed writing by the juvenile. A parent or guardian may not waive the right for the child, and it's codified in statute that when considering the waiver of counsel, the court has to consider age, intelligence, education, emotional stability, complexity of the proceedings. And if the child has been appointed an attorney already or has an attorney, the court has to ensure that the child has been able to consult with that attorney prior to waiving on the record. That you know, if you have something good but you haven't had the opportunity to understand why it's good or to really have that conversation, it might not be a knowing or intelligent waiver really. This is continued. Like I said, only the child can waive the right. We already, of course, know that it's always the child on the record the judge has to have the colloquy with, but again, it's further codified in statute. And then finally, again, statewide, there are situations where waiver is just not permitted. So if the child is under the age of 14, 13 or under, that child should have a lawyer, and that applies statewide. If there is a detention hearing, every child across the state should be represented at a detention hearing. Similarly, any dispositional hearing where out-of-home placement is sought. And then finally, if there is a motion to transfer the case from juvenile to criminal court, that's a complex set a requirement that the Supreme Court shall issue standards for all attorneys practicing in the juvenile court. There's been some movement to support kids' access to counsel in juvenile court. As Christine mentioned, you can get online and sign on to the National Juvenile Defender Center's Statement of Principles, and the hot link is there, gault@50.org, get involved. You can look at your jurisdiction's current practice of appointment of counsel and how it can be improved. Potentially reach out to your local Through the Eyes of the Child team to get on the agenda and talk about this, talk about these numbers and the importance of counsel in juvenile proceedings. And similarly, so talk to judges, but also contact your local legislator about the importance of juvenile defense. It really, in the debate this past year on LB 894, it became clear that you know, senators had mixed understandings of what juvenile court was and what could possibly happen in the juvenile court. So to whatever extent, especially if you practice in a rural area and can speak to your legislator and say, hey, here's exactly what can happen to a young person coming through juvenile court, even on what seems to be a really insignificant charge, there are possible significant consequences. And if it was your kid, would you want them going ahead unrepresented? Could potentially make a difference if the legislation is brought back, and it may well be brought back. And then the final thing you can do, Christine is going to go through, and part of their mission going forward is to help attorneys examine your own practice as a juvenile defender. What are you doing that's great and helpful for your clients, and what changes can you make to better represent your child clients? So Christine has some survey data to start us talking about that.
Yeah, this is data I'm going to go through that we collected from 89 youth, primarily from Douglas County Youth Center and through direct mailings. The youth that we surveyed were asked 37 questions about their knowledge about their attorneys, their interactions with attorneys, and perceptions of procedural justice or fairness. So, it's a pretty small sample. We're continuing to collect data on it, but I just wanted to share some of what we've found so far. One, most juveniles do think their attorney is there to support them, so that's good. There was a higher amount. If the parent hired the attorney, more juveniles thought that the attorney was there to support them. And then 77% correctly thought that the role of attorney is to do what the youth wants, that client-directed representation. What we also found is that lawyers need to educate their juvenile clients about their role and even just different terminology that can be used. 75% of you thought attorneys were different than lawyers. 61% thought attorneys were appointed by judges, but lawyers were hired, so they thought there was a difference there. And then only 85% of the youth that we surveyed were aware that they had an attorney. And Juliet and I were both public defenders too. That doesn't even go into, I had a lot of clients who didn't think public defenders were attorneys, right? So you had to explain, yeah, no, public defender is an attorney, is a lawyer, it's all the same. So really taking that extra time to explain that. Also, we found that lawyers could do a better job of educating their clients about confidentiality and, privilege, the attorney-client privilege. Only 31% of the youth said that their attorney could not tell their parents, the judge, the police, or their probation officer what they talk about without permission. That's a really low number. We broke it out by different groups, and there was a higher percentage of youth who thought that the attorney couldn't tell a police officer what they said, but they thought they could tell their parents or a probation officer. So only 31% of the youth knew that there was that attorney-client privilege and that confidentiality. And then also one youth at Douglas County Youth Center also indicated they're like, I don't think they should or they can, but they do. So so really just some of those perceptions and the importance of building that rapport with your client, that trust relationship, and really clearly explaining that confidentiality, attorney-client privilege would go a long way in your practice.
So this is very minor, but in regard to that, one thing we can all do is really consider the language that we're using when we talk to our clients. So some states have actually codified specialized Miranda warnings for youth. You have an example from Illinois there. There's another example from Washington State where they really deliberately used like a 6th grade reading level to make sure to have a high readability score for kids to understand, not just to hear the words going over their head, but to try to really get at that developmentally appropriate language. And this is something that as lawyers we can and should do with our clients. We know that on average our clients coming into the juvenile court are reading at lower levels than youth do on average in Nebraska. And so especially when we start talking about complicated legal proceedings, it's so important to take a step back and check our jargony language, but even our really basic language, since Christine highlighted that many of our youth believe there's a difference between the words lawyer and attorney. So one thing you can do is if you have, as a lawyer, you have words you tend to use with your clients. I know I had kind of a script that I would that I had in my head that I'd go through when appointed to a new client, meeting with them. Type your script or whatever you say to your kids into a readability score. There's a website you can go to. I'll give you the link. It's https://readability-score.com. You can literally type your words into a text box, and it will. There's different kinds of scores you can get it to chew back to you, but you type it in and it'll tell you what grade level you're speaking at, which could give you a sort of a gauge about whether your clients, depending on what age they are following what you're trying to say to them. So with that, that wraps it up for us. Do we have any questions from anyone? I'll give you a minute in case you're typing.
Or even comments too about what's happening in your jurisdiction, things that have been helpful where you practice, or things that you can share with the group.
Well, if we don't have any questions, thank you so much for your time. Hopefully the handouts and the PowerPoint are helpful for you. We've also got our, we have one. Got our information here, so you can always reach out. Gail asks, Christine, do you want to discuss some of the trainings that can be offered, see if there's an interest for training on a specific area?
Thanks, Gail. Yeah, so I mentioned that there were some attorneys on the call who had recently gone through a trainer certification process with partnering with the National Juvenile Defender Center. What NJDC has developed is called the JTIP program, Juvenile Training Immersion Program. It's a series of 12 different sections that is kind of the gold standard in training for defense attorneys. It goes from very beginnings of representation through motions practice, through disposition, through post-disposition, even reentry hearings, adolescent brain development, competency hearings. You said motions, but motions to suppress. Really, the whole gamut. I can send out to everyone kind of the whole list of the course offerings, but now we have 13 Nebraska attorneys who are certified trainers in this curriculum, and we can be available to you and your communities if there's a need you see where there needs to be more training. An assessment that was done in 2010 that was funded by the Nebraska Legislature found that there is a high demand for specialized training, but a lack of offerings. So if anyone wants to chime in today, we have someone else coming in with any needs, we definitely would love to work with you to get that information out to the bar, because really there's we want to create that network of support. Unless you're in a big office, there's a lot of defenders who are going it on, and so kind of creating that mentoring, fraternity of defense attorneys.
So, Ariana, I don't know if you guys can read these when I pull them up on our screen or not, but I'll go ahead and read them just in case. Ariana says, hi Christine, I'm a fellow for the NJDC with Legal Aid of Nebraska. I'm doing juvenile reentry work and I'm looking to connect with juvenile attorneys. You mentioned the Eyes of the Child team. Do you know how I can get in touch with them?
Yeah, so Lancaster County, Lancaster County has a Through the Eyes of the Child team, and the team coordinator, I believe, is also at Legal Aid, but I can send you a message too. But the Through the Eyes of the Child teams is through the Nebraska Court Improvement Project. So CIP has a website as well that lists all the different Through the Eyes of the Child teams. But Ariana, I will send you a message as well with that link.
Pam asks, is there a plan to monitor rural courts for compliance with appointment of counsel? That is a really great question. So again, there have been some studies in the past that have done court observation in Nebraska and found, as you might expect, that some of these rates of waiver are not just children and parents refusing, but are related to courtroom practices. So the senator who sponsored LB 894 this past year, Senator Pansing Brooks, she's got an interim study looking at access to counsel statewide, and I think there is some consideration of doing court observation for the purposes of that interim study and potentially bringing back the legislation to make it statewide in either next year or in a future year. I also know that the Court Improvement Project is additionally doing court observation through one of their projects, and I believe appointment of counsel is a piece that they're looking at with that. But that being said, I don't know of any formal monitoring plan to make sure that that courts are complying with the statutory changes from LB 894 to make sure that, say, kids younger than 14 aren't waiving counsel. And the best I can say to that is for practitioners in those areas, if you're in court, be keeping your eyes and ears open, and please always feel free if you see something to either reach out, say, to the judicial head of your Through the Eyes team, if that is working, or to, to the two of us, and we will see what we can do on the statewide level. Because, of course, we know legislation can roll out, but whether it changes practice on the ground can be a separate challenge.
Yeah, and sometimes you don't even realize things are going on. I was in the public defender's office too before Douglas County went to the appointment at filing. I just happened to be in like a mass arraignment because I had the client on another case and they got a new charge. So I happened to be in there, but the judge's assistant came in and basically said, if you did what they say, you don't need an attorney. If you didn't do it, then you should ask for an attorney. So I didn't even, didn't even know that kind of practice was going on until I was there. So really, keeping your eyes and ears open, and letting Juliet and I know if there is, if you have noticed something, so then we can take a closer look at it too. Because it really is a group-wide effort.
The other thing I would add is, presumably, since you're listening to this webinar, you're probably a member of the Juvenile Law section. If you're not already signed up for the Listserv, it's a great resource, Lawyers Helping Lawyers. Or if you're not a member of the Juvenile Law section, strongly encourage you to join the section and join the Listserv. People are always ready to answer those questions that that we all run up against sometimes.
Yeah, and they'll be at the annual bar meeting too. There's going to be a great juvenile law section seminar the first day of the conference from Dr. Marty Beyer on kind of a developmental approach to juvenile court practice. And then immediately following that will be the juvenile law section meeting as well. So being there, being present to talk about what you want the section to work on and look at over the next year would be great.
Thank you all so much again for taking the time with us. Please take down our contact information in case you come up with additional follow-up questions or information needs, and we're really happy to be here with you today.
Yeah, thanks so much.